Well, what we're seeing right now, we've just heard how the CBI top number 2 official Rakesh Asthana, along with the Devinder Kumar, who was arrested, they have moved court asking for quashing of this FIR against them. Well, one of the things that NDTV has learned is that we've studied that FIR, and what comes across is very, very curious. If you look at that FIR very closely, it says very clearly that it has been filed under section 13(1)(d). Well, that sounds normal. It's one of the main corruption acts that's been used against people in official positions. However, what people may not know at home is that 13(1)(d) is no longer there. That's correct. That entire Law Prevention of Corruption Act was amended in July in the parliament session at that time, and the entire clause of 13(1)(d) has been done away with, which is very curious. October 15th is when this FIR has been lodged against Devinder Kumar, against Rakesh Asthana. Those are the two main accused, and also against Manoj Prasad and Somesh Prasad, the two brothers who were said to be middlemen who helped Satish Sana pay off a bribe allegedly to Rakesh Asthana of, well, they demanded 5 crores, they got 3 crores. Now, 13(1)(d) in fact was the old Corruption Clause Act, which has been put under various officials, whether it's A. Raja, former telecom minister, or whether it's O.P. Chautala, former chief minister of Haryana. And the earlier clause said that if you're if you are a public official and if you misuse your position, thereby giving pecuniary advantage, that's the legal terminology. If you give advantage to someone by misusing your position, then you can be charged under this. Of course, in July, this was completely done away with. And what the new clause now says, the section 13 now says, is that you have to be a public official, and then not only do you have to benefit someone else, you also have to show that you've received, the public official has received benefit, and only then can a corruption be proved. They made it much tougher. Also, what's very curious is that section 6, which was the sanction bit, which meant that you have to file a PC Act, a Prevention of Corruption Act, only by getting permission from the government. In this particular one, we know very clearly there's been no permission that's been sought from the government. So why is it that an agency which actually is an expert in looking at corruption cases, that an FIR which perhaps has been vetted by their Directorate of Prosecution who specifically looks at this, how is it that an agency which deals with corruption cases would use an old law? Well, NDTV asked the CBI spokesperson, why is it that they've used a clause which no longer exists, and thereby insiders telling NDTV that that means that Mr Asthana and Devinder Kumar, that they only go to court and tell them, look, they've used a law which no longer exists, and it gets quashed. Well, CBI spokesperson said, let the court decide that. They also seem to feel that because some of the acts may have taken place before this entire thing was, before this new law came into place, that's why it could apply. However, that looks like very tricky legal territory, and we have to wait and see how that works out.